prosecutorial discretion, the power that the government has to drop a case. We know that we have a memo that came out back in April, pretty much directing ICE attorneys to dismiss certain cases based on the fact that those cases are low priority, they're non-priority cases, and they're using up resources, and there's a backlog in court with the immigration court, and they just want to really go to the cases that deserve to be adjudicated, in other words, and then just dismiss other cases, and certain people can just go back to USCIS and adjust status if that's the case for them. We know that. But in this video, I really want to tell you something about that dismissal, and I want to tell you that if the dismissal is not applicable to you, you shouldn't be taking it, especially if the type of relief that you are asking for is not available before USCIS. So you have to stay in court and oppose that motion to dismiss. That's the reason of making this video. My name is Bijoux.ngwanda. I'm an immigration lawyer here based in DC, for those who do not know me. And I do work with individuals across the country and around the world, because we are dealing with complex immigration cases. If you're new to my channel, you can go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing, of course. Don't forget to hit the notification bell so you don't miss any of my videos. Please like if you enjoy the content, of course. Share with your friends, and then just really give me a thumbs up, because YouTube will be able to share this video with people just like you who might benefit from it. Okay, let's get straight into it. If you are in removal proceedings, or somebody that you may know, a family member, relative, friend that is in removal proceedings, please let them watch this video. What's going on is this: ICE is sending out joint motion to dismiss proceedings. Okay, but the thing is, if the person in removal has asked for some type of relief before the immigration judge, and that type of relief is not available before USCIS, that person has no option but to stay in court. Okay, for example, cancellation of removal for people who are in court, and the only type of relief that really is available to them is cancellation of removal. They have no option but to stay in court, because if the case gets dismissed, they can't go to USCIS and ask for cancellation of removal. USCIS does not have the ability to to cancel your removal. So if you have a strong case, a cancellation of removal, strong case, because that case is actually difficult to actually win. But if you have a strong case and you have a cancellation of removal case, really, my strongest suggestion is to stay in court, oppose that motion to dismiss, stay in court, and try to argue your cancellation of removal case before the immigration judge. Okay, so that you can get your removal canceled, and then later on stay on the line, as you already know, until the visa becomes available for you to get a green card. Because if you get your case dismissed, how else are you going to get that green card? Because if your only option was cancellation of removal. That's just one example. The other example is if you have asylum that was filed outside of 1 year, and then USCIS refer you to court, and you have strong evidence to show the judge. So you can't just take that dismissal, because you have no other option. Because when you go back to USCIS with the same asylum case that they already decided on, my friend, you're just going to get another denial. So the solution for you in that case will be to stay in court and fight for your asylum in court, and hopefully get that case basically granted or approved, right, in court. So it just depends on the specifics of your case, and it depends on how strong your case is. That's why you really have to assess your case and find out whether it's the best option for you to fight that motion or to get it joined so it can get dismissed. It's really, you have to look at first of all, the type of relief that you're asking and the type of case that you have. Okay, those are just two examples that I'm giving. But in certain circumstances, right, certain individuals, dismissal is good for them because maybe they have an approved petition. Maybe now that they have an approved petition, they have to go back to USCIS to apply for adjustment of status. Maybe in that case, it's good for them to join the motion to dismiss and get their case dismissed. You know what I mean? So it just really depends. That's why it's really important to get like a second opinion from somebody else to give you that second opinion to know really weigh your options right there. Okay, you just don't want to dismiss your case and just stay like that without any type of way for you to adjust status. Certain individual, again, that were referred to court maybe because USCIS find out that your asylum is frivolous. Remember that the asylum one is frivolous. You have to have the opportunity to be heard, right? You have to have the opportunity to be heard before the immigration judge. But if I dismiss the case, then it means that charge has been forgiven, right? But in that case, I don't think the ICE will be really like wanting to dismiss the case. That way you should stay to fight for it, because once it has been determined that your asylum case is frivolous, that's a permanent bar. You cannot adjust status later on. So the moral of the story, or the purpose of this video here, is to really carefully weigh your options when it comes to prosecutorial discretion. It's good for certain cases and it's not good for certain cases. So don't be in a rush to join that motion to dismiss, because we have certain individuals in my practice that we have been asked by ICE attorney to join the motion to dismiss, and we have opposed that motion because those clients do not have any other option but to actually fight their case in court. That's it. So it just depends. Again, you can call me for a consultation, 202-751-2180. Email is Bijoux.ngwandaesq@gmail.com. We do charge for a consultation. Fees apply. But really, you really want to get a second opinion, and if you find out that we are the good person to ask for a prosecutorial discretion, or to really join those motions, or to just really ask for the case to be terminated so that you can adjust status with USCIS, then please call me again. Until next time, bye bye.